Hello, everybody, and thank you very much for joining. So, what we're talking about in this session is basically how you prepare for a sale of your business. So, before we start, a little bit about us as a firm. So, we work exclusively with startups, and that makes us quite unusual in the market. So, obviously, a lot of our competitors, they do bits of startup stuff. This is very much what we do. So, startups is literally everything that we do. In terms of the size of startups, we work from everything from pre-incorporation, so with founders essentially, all the way through to sort of late series ABC. The sweet spot, I guess, for us is probably that sort of pre-seed to Series A section. In terms of M&A, which is obviously what we're talking about today, most of our clients are sort of sold between 50 million, 200 million stage. And so if we move on to the next slide, just about M&A, the sort of work that we have done recently. Ivan, next slide. So the sort of typical transactions that we tend to work on, as I say, between a valuation of 50 million and 200 million, that tends to be the sweet spot. We do lots of stuff sort of smaller than that. Generally on that level, it's sort of more on a sort of distress side. But yeah, the sort of deals that are most common for us in that sort of space. Our clients, when they're sold, they tend to be, if they're scale-ups, they tend to be post-Series A, often sort of Series ABC, or they're businesses who have got to profitability or at least broken even, and they're sort of selling at that stage. And typical buyers tend to be trade buyers, generally private equity backed, sometimes VC backed. So in other words, bigger companies with deeper pockets. A couple of recent transactions we've acted on. To give an example, just before Christmas, we worked on an effectively an asset tracking telecoms business. They were bought by a private equity backed trade buyer for about 80 million quid. We worked a little bit earlier than that on an encryption software business. That was actually quite an interesting business. They were acquired by another startup that was backed by, admittedly, a very big VC. Interesting deal, actually, because in a way, and actually probably the way it's turned out, our client, the target, was actually the better business and has since become a larger part of the value of the sort of acquirer's new group. And third example, we acted for a cosmetic product retailer who did a 180 million quid exit at the start of last year. So there you go, sort of three examples of some of the stuff that we do. In terms of the structure of this presentation, we're really going to cover, three main things. The first is the sort of steps that you should take in preparing for a deal. So what you should do in order to get yourself ready. The second is the sort of due diligence that you need to think about. So, what the buyer is going to want to do in terms of DD. And how we prepare for that. And then finally, we're going to have a little bit of a look at how the due diligence feeds into the contractual documentation. So, starting with the first topic, super important point, finding the right buyer. Something, ironically, that not all clients prioritise. Sounds weird, but is a mistake that does happen. So, Mary, do you want to tell us a bit about sort of finding the right buyer and the sort of things we're thinking about?
Yes, so when we're saying find the right buyer, we're really thinking about two different things. Firstly, obviously, really key is that the buyer is going to have to be aligned with what you want to get out of the sale. And that could be slightly different depending on your business. So, for example, if you're planning on staying on in the business after completion, a sort of a key person, you might be wanting the buyer to understand that you want sort of incentivization provisions and out provisions in there as well. And so that's going to be a key factor in negotiating the deal. Equally, if you're planning on leaving the business after sale and setting a completely new venture, you're going to want to make sure that the buyer is completely aware of your intentions to do so, especially if it's in a sort of similar space. I think making sure the buyer understands that and is aligned with that at the outset is really key, because again, it just makes sure that you're sort of avoiding any negotiation issues or nasty surprises down the line. And then secondly, perhaps the more important bit is just essentially just knowing who your buyer is physically. What entity is buying your business. who is it made up of, how they're paying for it, is it cash or is it by lending, so really for sort of legal AML purposes, but obviously it's important to know where your business is going to sit within the buyer.
Yeah, and I think from my side, there's always sort of the two big points here are, number one, most deals in the current market, there is some form of deferred consideration. So probably an earn-out, but it could be something else. It sounds like a statement of the obvious, but you actually need to make sure the buyer is going to be able to pay the purchase price. And it is not uncommon, frankly, that buyers are not in as strong a financial position as you might want. So that's always a crucial thing to have a think about. And the other thing is, most founders will find that they are tied into the buyer for a period of time after completion. You kind of need to figure out that these guys are people you can work with. When you think about M&A transactions, it isn't a wham bam and that's that, we're done with the business. It's a partnership going forwards, and you need to make sure that these are people that you can work with, that they have the same values that you have. So, I mean, as an example, imagine that you are, you're a business, you've grown up a, organic, vegan, animal-friendly cosmetic brand, say. You need to make sure, presumably, that those same sort of priorities are held by the buyer. Why? One, presumably this matters to you. You've created a product like this for a reason. But also, two, if you've got an earn-out and the performance of your business going forwards is based on that, you don't want to alienate all your customers who care about vegan stuff because your buyer suddenly doesn't and is going to sort of drop that kind of thing. So finding the right buyer is probably the most important thing up front. So we've got probably offers from a couple of people. We've identified some different potential buyers for us. The next step we need to think about is how are we going to structure the deal? What are we going to do next? So, Mary, what are your thoughts on sort of appointing advisors? What would you think about that?
Yeah, so essentially once you've found a buyer, or indeed maybe before, you might want to think about appointing, if you're not sort of able to find a buyer by yourself, appointing some sort of financial advisor. And these are essentially estate agents for the sale world. And they'll basically go out in specific areas relating to your business and try and find a potential buyer for you. So appointing them, obviously, at the point you decide that you're going to sell is going to be important. You have to be a bit careful because they will be often commission-based, so normally a percentage of the consideration price, and they'll only sort of be paid once the sale completes. So you need to be cautious that they are finding the right deal for you, that the terms are correct. Also being wary of introduction terms. It might be that the terms mean that if you find somebody yourself, even within the term of the agreement you have with them, that could mean that they're still owed a fee. Things like this have happened in the past, so yeah, just being cautious of that. Also in obviously legal teams and financial teams as well. So you might already have in-house legal and financial teams, obviously, that deal with your tax and books and stuff like that. But I think it's really important to also think about appointing transaction-specific legal and financial advisors. So on the legal side, going to be really important because it is some things that we'll come on to talk about in a second, really early stage things to discuss. But also taking a look at the business initially, seeing if there's any issues in terms of shares, contracts, stuff like that. They can basically start as soon as you instruct them, they can start essentially doing a bit of DD on your business to make sure any issues are ironed out. And then on the financial side, obviously you're going to need to put a valuation on the business before or when you approach a buyer to sell. So having a really dedicated financial accounting team can help with that, as well as due diligence later on down the line. You might also want to think about appointing certain members internally as well to liaise with those advisors. So obviously, if you have a bunch of sellers, it's not shareholders, it's probably not going to be advisable to have them all CC'd on the chain with legal and financial advisors all the time. So perhaps appointing a few key founders maybe to play that role, and also making sure some of your own in-house financial and tax and legal people as well are involved so that they can help to provide the appointed advisors the right information timely.
Yeah, I agree with all of that. And I think for me, the sort of three big points are always, make sure that the agreement with the financial advisors is reviewed by lawyers, because the financial advisors, for obvious reasons, they want to get a good deal out of this. And so there are lots of terms that are potentially problematic that you may not necessarily think about when you negotiate the agreement with them. A good example might be often financial advisors are commission based, so they get a percentage of the deal. You need to worry about what that percentage is based on. So there are generally two approaches. It can be based on the headline deal sum. So let's imagine business is being sold for 100 million, 40 million quid up front, 60 million or up to 60 million through an earnout. That earnout isn't guaranteed. It's going to be based on the business meeting certain performance milestones after completion. So from the sell side perspective, from your perspective, you want to make sure that the financial advisor's commission is based only on the cash you actually get for the deal and not on the headline 100 million valuation. So getting that sort of agreement reviewed is important and a priority. I think the second thing, as Mary said, is around internal team. Deals like this can be massively draining. They can, if they're not handled right, you can find that the management, the founders, spend virtually all of their time for an extended period of time. I mean, what, four weeks to maybe 3 months focused on this deal. And the irony is that you can actually damage the business in the process, and particularly you can damage your earnout or the chances of you getting your earnout because you're not focusing on the business. So, either making sure that you've delegated running the business to people that will do it properly, and you can effectively step out for a period of time, one option, or bring on people on the deal side who can do the heavy lifting, so they can pick up documents, they can figure out what needs to be given to the buyer, so they can do all of the time-consuming stuff, and you as a management team can focus on the sort of big ticket stuff. And I guess the final point from my side is don't skimp on advisors in the early stages. We'll talk a lot about preparation actually in a moment, but the key things to think about are in these early stages when you're negotiating a deal, you need to make sure you've got the right people in place, and that really does include lawyers, financial advisors, tax advisors. So get all that stuff done up front. That sort of neatly actually brings us into the first document, if you like, that we have in place on M&A transactions, and that's the heads of terms. So Mary, do you want to give us an overview of the kind of stuff we're thinking about?
Yeah, so heads of terms are essentially a letter of intent between the buyer and the seller, setting out the key aspects of the deal as initially agreed. So they're not generally famously legally binding, apart from a couple of provisions to do with confidentiality and exclusivity. But it's really important because it's a stage where you can really sit down with the buyer, with your legal team, express what you want out of the deal, and get it down in the heads of terms to be signed at the very outset. And the heads of terms will deal with a lot of detail in relation to the structure of the deal. So, for example, price. Obviously, it will reflect whatever valuation that has sort of been initially found for the sale. And also it might mention things about will there be any adjustments to that price either before or after completion, and how that is to be agreed. So it might be at a generally high level, but there'll be a bit of detail in there as well. Structure and split of consideration, so really important obviously if it's a share sale, who the shareholders, what proportion of consideration is going to be paid to each of them, and also whether it's going to be all up front or deferred or a mixture of both, and what that split looks like. You're going to have, if it's an asset sale, obviously a description of what specific assets you are selling, and probably also what is being excluded as well. And then exclusivity as well is a big one we mentioned before. So this can be quite a contentious thing to discuss at the start, but it's really key for heads of terms. And it's something buyers probably going to ask you to basically make sure that there's a period of time defined where you are essentially locked into conversations with them about a sale and not with anybody else. So obviously, if you're really keen to sell, you're probably going to be wary of setting too long of a deadline. It does have to be reasonable, and it can be a useful tool to sort of focus negotiations, because the buyer might want a longer period of time. It's important to make sure that we negotiate an actual reasonable but also not too distant exclusivity period date to sort of protect the seller's interest. So
yeah, and exclusivity is always it always becomes a little bit too contentious, to be honest, and it's important to try to be balanced on it and try to use it in the right way. The way I look at it is you want a relatively short but achievable exclusivity period. So you want to focus people to try and get the deal done. what you don't want to do is on the sell side is you don't want to end up in a situation where you're tied into a deal that's not going anywhere when you are not able to talk to other potential buyers when really and truly the deal's dead and you want to move on. That can sometimes be achieved by a party being able to give unilateral notice, just terminate the negotiations and move on. But it's important to kind of think those things through. I think more generally in terms of heads of terms, my view is it's worth taking time to negotiate them and to get a bit more detail into them. I'm certainly always incredibly nervous when clients want to, and it does happen, they want to jump the heads of terms stage. I think the way to think about it is you want to have arguably difficult discussions up front in the heads of terms space when you're evaluating whether this is a deal you want to go ahead with and you haven't incurred too many costs in terms of advisors. So have those hard conversations up front and don't sort of park them until later. If you get the heads of terms right, you're going to have scraps with the buyer as you go through negotiating long form docs. There's going to be an inevitability of the things that need to get negotiated. But if you get the heads of terms right, you can hopefully minimise the potential disputes later. And that just makes it an easier deal, a quicker deal, and frankly, a much cheaper deal in terms of advisor fees. So yeah, really focus on heads of terms. Even if that delays the deal by a couple of days or a week, it's going to be worth it in the long run. So we've got our heads of terms in place. We then sort of move on to due diligence. Now, due diligence is one of Mary's absolute favourite topics, isn't it? And when we're sort of when we're looking at due diligence, it's really about the buyer finding out about the asset that they're buying. So Mary, do you want to give us a brief overview of what due diligence is? What are we talking about here?
Yeah, so I guess we're at the stage where we've signed heads of terms, everything's sort of signed up, and now the buyer just is basically going to do a fact-finding investigation into all aspects of your business, especially if it's a share sale. What are they inheriting? And the way that process sort of takes place is, it may well be actually that if you've appointed, a good lawyer beforehand, they've already started to look into certain aspects of your company. But the buyer's legal team will at this stage send a due diligence questionnaire, which will cover areas such as legal, commercial, financial, and tax. Essentially asking questions about certain aspects of the business that we need to reply with responses to. Sort of things you might find in that questionnaire. So really big one at the front of the page will be corporate structure. So asking questions about shareholding, where does the target sit? Is it part of a wider group, and are we just selling the target itself? Because that's going to identify for the buyer, do we have to do some sort of pre-completion restructure? And also if there's obviously any problems with transactions that have happened previously, were they properly done? So there'll be questions to sort of identify those sort of things. Contracts as well. So this is a really big one, especially if the reason the buyer is buying your business is because of your access to certain customers. So they're going to want to see copies of either a key set of customers above a certain revenue mark, or all your customers. And they'll want to see agreements that are signed properly, that are up to date, not expired. So they'll be requesting that sort of thing as part of due diligence as well. Compliance wise, so there's a few sort of sub areas where this might come into play, but they'll be asking about data protection is obviously a key one. So are you registered? If you need to be registered, do you have appropriate privacy policies in place and internal employment privacy notices as well? For example, if you're supposed to be registered with the FCA, are you properly registered? Is it all up to date? Litigation as well is another big one. That there'll be a really broad question as to whether there's been any historic litigation in the company, or potential for litigation as well. Is there potential for an employee claim? And that you're really going to have to present those issues to the buyer as early as possible, so that they can be dealt with later on.
Yeah, and I think due diligence is something that is a bit of a pain. I mean, it's a massive pain for the sellers, because they basically will get presented with often a 40-page disclosure questionnaire with an absolute ton of questions, some of it relevant, some of it easy to respond to, some of it incredibly difficult to respond to, some of it appears completely irrelevant. And they're expected, obviously with the help of lawyers, to go through it and provide all of the relevant information. So it takes a huge time, it causes a massive distraction, and it's generally pretty painful for everybody. I think you know, the important thing, really, and we'll talk about preparation in a sec, but the important thing here is it's an important process. The more streamlined you can make it, and the more time and effort you put into this due diligence process the first time it comes up, the easier the deal is, and arguably actually the better the commercial terms will be. So that sort of leads us on to the question: we're doing all of this disclosure, and we're doing all this due diligence. Why the hell are we doing it?
Yeah, it can be difficult or easy to lose sight of why the sellers are putting so much effort into it. I guess you can, you're thinking of it from the buyer's side. You know, they're wanting to make sure that the valuation that you've put on the business is valid, and that the information you provided supports that valuation. You know, they want to know if there's anything that could potentially leak value from the business, and ultimately as well to identify any issues that they're going to have to deal with and negotiate on as part of the main transaction as well. So I guess the earlier we can identify on the sales side any issues, deal with them, is going to make it less, at this stage, it's going to make it less likely that the buyer is then going to want to, you know, discuss a change to the valuation of the purchase price, or, you know, sort of heavily negotiate any issues further down the line. So I guess it's, for us, it's as early as possible as sellers to identify issues on our end, because, you know, it might be that, you know, there are certain things that your lawyer identifies that you've not necessarily thought of, and so it's very rare that you get nothing. So yeah, I guess it's the earlier the better for the seller to really go through with the fine-tooth comb and identify those, in light of why the buyer might want to discover any issues as well.
Yeah, I'd second that. I think preparation is absolutely key, and this really comes all the way back to the first section. You know, you want to get advisors on board as early as you can. You want to have people thinking about disclosure, thinking about what's going to be asked in terms of due diligence. And in an ideal world, if you can do it, you actually want to get your lawyers and financial experts looking through all of your documentation, all of your records, and really troubleshooting problems. No matter how organised you are, you know, even the most organised and most conscientious businesses, there are going to be problems. It's just inevitable when you run a business. Stuff isn't always done right. It is a hell of a lot better that we find that before you end up disclosing stuff to a buyer, rather than the buyer finds it and you get some annoying lawyer on the buy side that goes, aha, gotcha, we should be worried about this. And I think, flippancy aside, if you think about this from the buyer's perspective, what the advisors are doing, whether it's the lawyers or the financial advisors, they're basically looking at what's been disclosed and they're applying what I flippantly call the sniff test or smell test. So they're looking at the information, they're trying to form a view. Is this a well-run company where they've really focused on getting stuff right? You know, contracts are signed and dated. You know, most of the key clients, or all the key clients, have got contracts in place. You know, we haven't got, you know, option agreements that have been registered on time. We haven't got those claims against us. Does it feel like a well-ordered business? If the answer is yes, then we're putting this feels like a safe, low-risk transaction. And as a result, we're not going to be demanding huge amounts of protection in the transaction documents. The flip to that is a business where the disclosure is a complete mess. You're disclosing documents with the clients that aren't dated, or they've got some signatures and haven't got other signatures. You've got, you know, financial records that are a mess. You know, you can see, you know, as a lawyer, you see that kind of stuff and you start to go, well, actually, this feels like a problem. And the instinct of lawyers is then to dig and dig and dig, because they want to make sure they're not missing something. So your job really as sellers is do the prep, make sure that at the point you are disclosing stuff to the buyer, you know what the problems are. And quite frankly, you are telling the buyer what those problems are up front. And as we'll talk about in a sec, if you tell that the earlier you disclose problems, the better it's going to be, really, in terms of transaction terms in the long run. So that's quite a neat segue actually into how due diligence feeds into contractual documentation. So there's sort of three bits to this, I guess. The first bit is in the share purchase agreement or the asset purchase agreement, that we what we call warranties. And those are basically statements of fact. If they're untrue, we disclose against it and we do a disclosure letter. And then, you know, the things that we have identified, or the buyer perhaps has identified as being problems, we then, or the buyer may then want to get some protection for them. So if we start at the beginning, Mary, tell us about warranties. What are they?
Yeah, so the warranties are essentially statements of fact, which, if are found to be untrue, can give the buyer a claim against the sellers or the warrantors basically for any loss that causes the value of the company. There is an obligation to mitigate that loss, and the burden of proof is on the buyer, so they are generally quite rare. And it's sort of difficult to claim, but it is an element of risk for the sellers. And you might get, in terms of how they look, so there'll be a schedule in the main transaction document, basically with a long list of warranties in all different areas, similar to the ones we discussed, due diligence. And so how does the seller go about dealing with those? So one of the ways you can do that, as we said, is by the disclosure letter. And this is basically a letter where you can set out to what extent those warranties in the main document is untrue. And the idea being that depending on your definition of disclosure, because it can be different and negotiated differently depending on the deal. But the idea is that once you disclose that against that warranty, that generally you're protected from the claim on the basis that the buyer was aware of it, and so they can't turn around afterwards and say, there's a breach of warranty here, there's been a loss, and claim against you. So what we have is a disclosure letter, and the way how that sort of looks is we'll have a set of general disclosures. So there'll be things that the buyer ought to be aware of anyway on completion. So for example, things that you can find on company's house, if there's anything that we put into a data room or documents provided in a shared box, then it might refer to that if you're able to negotiate that. And then there'll be a whole list of specific disclosures. So these will literally refer to specific warranties in the main transaction document and explain as to why they are untrue. And you'll probably provide, or you definitely want to provide some sort of supporting documents, evidentiary documents to go with those, so that the buyer has seen them, and they'll be included in what we call the disclosure bundle. So that is essentially another option, another way that the sellers can protect themselves. But like I say, it depends on really the different definition of disclosed.
Yeah, and I think the way to think about this is there's almost sort of there's two bits to this. There's the first bit is the due diligence process, where you're obviously disclosing against the questionnaire. So you're disclosing all the relevant documents, you're answering a bunch of questions, you're explaining or giving the information that the buyer's asked for. So that's the sort of the first bit. That is separate to and distinct from the disclosure letter. So it's incredibly rare that you would ever have what we call general disclosure. And general disclosure just means that everything in the data room or everything that's been disclosed previously is deemed disclosed against the warranties. And frankly, even if you were to get that, which as I say, very unlikely, but even if you were to get that, you would still do a disclosure letter. And in the disclosure letter, as Mary says, we're in respect of every single warranty, we're explaining why it's untrue, where it isn't entirely true. So I think the important point, and a lot of clients on the sell side will sort of turn around and go, well, why are all these warranties in this agreement? The buyers know these aren't true. We've already told them, we've given them the documentation. And actually, it sometimes really annoys sell side clients. But it is just a weird way that we do this. And so even though you disclose everything, we still have to do the disclosure letter. What I would say is, if you think about the two main work streams on a transaction, there's the share purchase agreement or the asset purchase agreement. So the transaction document, the main one, and then there's the disclosure letter. They are the two most important bits. Most of our time is spent on those two things, and actually probably more time is spent on the disclosure letter than is on the SPA. So it's super important, and that process is something that we just have to get right. We've done our disclosure letter, Mary. We've told the buyer all of the reasons why the warranties are untrue. We've given them complete and incredibly detailed explanations of the problems that are in the company. Is that it? Can we sign the deal, or is there something else that happens?
Very unlikely that will be it. So, it might be that there is just something that's come up as part of the diligence or disclosure that the buyer does not want to take the risk for. Or there might be something that via disclosure, going through the disclosure letter, there's something new that's come up and they're not aware of, and they don't want to take the time or have the time to sort of be completely aware of what risk that might pose to the business post completion. And so in that circumstance, it might be that they even negotiate that you can't disclose against that particular thing in the disclosure letter. And what they probably will ask for instead is what's called an indemnity. And an indemnity is different to a warranty. It's basically a promise from the sellers to reimburse the buyer if a specific event or loss is incurred. And that's on a pound for pound basis that loss can be reimbursed. And it's generally easier for a buyer to claim an indemnity rather than warranty, simply because they don't have to mitigate loss as they would have to with a warranty. So it's generally easier. So it's generally more riskier for sellers to accept those indemnities, and we wanted to get legal advice on those. It might be though that because of the proximity to completion, or because of the the negotiations with the buyer, that depending on what loss we think might be caused by that specific indemnity, the sellers might be minded to accept it. Again, like I say, purely just because it might be something that, compared to the consideration price that you're getting, is generally lower or quantifiable to the point that we can sort of take that risk on. But we were wanting to put in some of the protections in as well in relation to that indemnity, to make sure that it's limited as much as possible. But it might be that the indemnity is the solution to get the buyer comfortable.
And Mary, you sort of hit the nail on the head there when you mentioned timing of issues arising. For me, you don't want to be in a position, frankly, ever, where as you get towards completion, an issue has popped up, it's taken possibly you, but also the buyer by surprise. And the buyer turns around and says, well, all right, great, but we want an indemnity to protect us because we haven't had time to diligence this, we don't know what the risk might be, and it's your problem, not ours. So here we go, we want massive protection here. And this really, it's forgive me for being a bit of a broken record, it comes back to preparation. If you just think about it logically, if you've identified all of the problems or most of the problems early on, you've told the buyer about them, and the buyer at that point has had a discussion, has had the opportunity to think about it, talk about it with you, and probably do some further diligence on those specific issues so they can fully understand what the potential liability is, what the risks might be. If they've had the time to do that, most of those problems actually will have gone away. They'll have got comfortable, they won't need additional protections. Flip that to the other end of the spectrum, 2 weeks before completion, a huge issue pops up that they weren't aware of, that's come out of diligence. They're not going to have time to diligence it because you want to get the deal done. They're probably at that stage fed up as well. They just want everything to be finished. And so they're going to look at pretty draconian protections to make sure that, they're not at risk and they're not going to get hit with a liability for something that they don't really fully understand. So really focusing on getting the diligence process done, getting it done quickly, getting it done in detail, and making sure that there's nothing that's going to take you by surprise is really key to all of this. For me, I think, the takeaway that I would say in terms of preparing for a sale, predictably, it is preparation. You need to make sure that you've done the thinking about what you're trying to achieve early on. The nightmare, and it does happen, the nightmare is sellers who, they kind of think that somebody says to them, oh, maybe now's a good time to sell, but they don't have a clear feel for what it is they want to get out of this. That's a waste of everyone's time. So understand what it is you want to get. Make sure that you've got the right buyer and that the people you're talking to are the right people for you and for the business. And make sure that you do the preparation work, that you get advisors onboarded on time, that you understand the problems in your business, or help somebody, or get somebody to help you understand the problems in your business, so that we're clear what it is we're presenting to buyers when we get there. So that's it from us. Ivan, do we have any questions at all?
Thank you so much, guys, for that. Actually, the seminar is quite busy tonight, so we've got quite a few questions. I'm just going to pick a few. The first question is from Sam. How should a seller protect himself from claims?
Yeah, it's a good question. I guess we talked a bit about, risks for the seller in terms of warranties and indemnity claims and that sort of thing. So one of the key things that is quite standard that you'll want to make sure you put in terms of protecting against claims is liability caps. So what you'll see in your agreement is something to do with a de minimis, which is basically a minimum claim value that the buyer can bring against you. So, for example, £10,000. If the buyer can't bring a claim in respect of any one matter that's below that amount, debate that was being that it avoids the buyer bringing minor or unsubstantiated claims, just for a bit back in the purchase price. You can also then set an aggregate so that the buyer can't bring a certain number of de minimis claims that are also below a certain amount. So again, it's making sure that those claims are not minor, just petty things. They are substantiated. Time limit as well, so we can set a cap on the time to bring a claim. For warranties and sort of general warranties, it'll normally be about 3 to 5 years as standard. Obviously, you'll be wanting to try and limit that on the lower side, maybe 1 or 2. And that will again just be focused. If there is a claim, they're not sort of waiting, down the line to bring it. They're able to bring it within that kind of couple of years post completion. For tax covenants and things like that, they're generally 7 years, and they're non-negotiable really. In terms of indemnities, what we can do in terms of adding a bit more protection in for sellers is essentially allow the sellers conduct of business. So that will include provisions that mean that the buyer can't. So, for example, if it's in relation to an IP infringement claim that someone has, sent a letter in saying that there's been an IP infringement, has never actually acted on it or brought legal proceedings, we can pop in the main agreement that the buyer can't sort of get in contact or poke the bear in a way to that person or company to sort of provoke a claim to come in so that they can claim on the indemnity. So there's just a few ways that we can provide some protection in the transaction documents.
I always like the idea of poking the bear. It's an amusing expression.
Yeah.
Thank you so much, Mary. We've got a question from Vicky. Are earn-outs a bad idea from the seller's perspective?
Yeah, I mean, so the funny thing about earn-outs is that they tend to be something that buyers are super enthusiastic about. So what an earn-out is essentially saying that, the buyer will pay perhaps some of the consideration up front, but then the balance of it, or a chunk of it at least, will only be paid if the business meets certain performance milestones post-completion. So from the buyer's perspective, they like it because, it potentially reduces the purchase price, because if the business doesn't meet the milestones, they pay less. And it also protects them from buying a dud to some extent. So if the founders, or if the business doesn't perform as well post-completion or doesn't perform as well as the founders expect, then they don't have to overpay, if you like. They're only paying for the business for what it's worth. So that's the theory of it. Flip side, sellers don't like it. It has the potential to effectively, from their perspective, reduce the purchase price. They are transferring at a high level control of the business to somebody else, and yet their ability to get additional sale value is dependent on that business they no longer control performing. So there's a whole ton of risk there, and you're basically leaving a bunch of cash on the table. So that's kind of the way that you tend to look at this kind of thing. Worth saying though, if you're forced to give an earn-out, or you're forced to agree to an earn-out on the sell side, there can be ways of turning it to your advantage. So the way to think about it potentially is, if you do meet your milestones, then you can potentially maximize the sell value. And if you can agree, caps or agree caps on an earn-out that are high and milestones that you believe are achievable, you can actually potentially get more for the sale than you would otherwise have done. So there is some potential upside for sellers there. And actually, to give an example, we did a deal just before Christmas where the initial proposition had a capped earn-out, and the buyer, frankly, bizarrely, but the buyer was super concerned about the business not performing, and they actually ended up trading the cap on the earn-out. So they got rid of the cap on the earn-out and made it entirely uncapped in exchange for some downside protection. Now, our clients were absolutely delighted because they were selling their business. They thought the milestones that they had to meet to get the earn-out payments were incredibly easy to achieve, and they thought that they could massively over-deliver. So removing the cap gave them an ability to get extra cash beyond anything that had ever been considered in the term sheet. And it actually turned out that way. They've ended up with about 10 or 12 million pounds more than they would have got on the original deal. So there is potential upside for sellers in earn-outs.
Perfect. Thank you so much, Mike. We've got a question from Alif. What are the key areas where you find the most issues in terms of due diligence?
Yeah, so yeah, it really depends on the business. And honestly, it can generally be things that you don't quite expect. One example I can think of is in a regulatory sense, a deal that we worked on for, this client produced sort of electrical cards and potential waste. And they always thought they were below the threshold for sort of registering with into the electrical regulations. So they hadn't registered, and the buyer picked it up that the legal team picked it up that the law had recently changed, where now they were, sort of it would apply to them, and so it can be really weird and wonderful stuff like that. So knowing sort of whether your the specific requirements or registration requirements in relation to your industry is really important. Contracts as well. I know we talked a bit about it earlier. It's always it's going to be very rare that you're going to have clients with fully signed contracts. Both parties signed, dated, in date. It just rarely happens because obviously you're just getting on with doing your business. But that's one that we always want to make sure that we tie down, just to limit any issues in negotiations, and make sure that they're all sort of written up and renewed and anything like that. Share issues as well. It could be that, especially if we found that, because clients don't often have properly written up statutory registers. So that's something that we sort of have to make sure that we're doing when we're advising clients. The nightmare situation is always if you've got like a rogue share held by somebody and we're trying to do a share sale. That's one that sometimes comes up. But yeah, I said there's a few things that generally we've seen in the past come up, but there can be some surprises in there. You never quite know.
Yeah, the one I always worry about is employees. So there's all sorts of weird and wonderful stuff that can go wrong with employees, and it can be super expensive if you've got employee claims. The funny thing is you're not going to pick it up unless you ask the question. And I think on a number of deals we've had that often it's all solvable, but there was a deal that we did recently where it transpired when we did the maths that the employees weren't being paid proper holiday pay. It wasn't because the employer was a bad employer, that they just made a genuine muck up. They hadn't quite figured out the way that holiday entitlement attaches to overtime. And so the numbers were all wrong. Now, it was incredibly solvable. The employees were paid relatively small amounts of money to solve the problem, but it could theoretically have given rise to employment claims down the line. So, really checking that the position on employees is always
Perfect. Thank you so much, Mike. The next question is from anonymous attendee. Should we be doing due diligence on the buyer?
Well, hello, anonymous attendee. So the answer is yes, you should, and it's super important. I think a lot of buyers can be quite resistant to due diligence being done on them. And you very often hear the sort of thing, well, hold on a sec, we're buying you, we do due diligence, not the other way around. It depends on the deal, but think about it this way. Most of the time, the management team are going to have to work in the business for a couple of years at least post-completion. You want to work with people who you can get on with, who are not psychopaths, who broadly fit the kind of people that you get on with and can work with. It makes total sense to make sure that they are your kind of people. And the way I would look at it is most people at least don't just accept any job that's offered to them. They want to meet some of the key members of the team. They want to see the offices, whatever it might be, but they want to get a feel that these are people that they can work with. So that's the sort of first bit. I think the other bit, probably the more important bit, if you've got an earn-out or you've got any form of deferred consideration, you want to make sure that the buyer is going to pay it and that they can afford to pay it, and that they are a broadly stable, solvent business. You're never. It's very difficult really to get that information without doing a little bit of digging and asking about, what the business is up to, see some financial records, get an idea for growth plan. So I think doing due diligence for me is an absolute no-brainer. But as I say, buyers can be quite difficult with it sometimes. It can be difficult to get all the information you want.
Perfect. Thank you so much, Mike. Next question is from Stephen. It's quite a good question. Head of terms aren't legally binding, so do I need to get a lawyer to review them?
Yes. Yeah, as we were sort of saying before, I think you can focus a bit too much on the not legally binding part. But as we were saying, it's really going to be a footprint, those heads of terms, for how the deal is going to play out. The more you can get in detail in those heads of terms, the better it's going to be for the sort of timeline of the deal and to limit the surprises later on. In terms of negotiation tactics as well, I think, you know, it really commonly, one of the main points that lawyers will shoot back and forth is that, you know, well, hang on a minute, this wasn't in the heads of terms, why are you springing on this now? So if you can sort of think about and get your lawyers to advise you on, you know, how you want the deal to be structured at the outset, you can limit that, and I think that looks good on both parties, really. You know, and the things that you should know as well, you know, to price its structure, you know, how it's going to look. It's things you're going to know, or you're going to sort of have an idea about how you want things to go. So there's no reason why you shouldn't get that sort of in the heads of terms at the outset. And in terms of, in terms of legal stuff, I'm a roll here. In terms of legal stuff as well, you know, there is still the confidentiality part and the exclusivity part. So you want to make sure that, you know, there's no guarantee that this deal is going to complete with this buyer. And so if you're providing confidential information to them as part of due diligence, you know, you're properly protected in that regard. So you want a lawyer to look at that.
Yeah, and I'd add, it isn't just lawyers either. It's also the financial advisors and the tax advisors. So if you think about the reason advisors are there is to add value, to make sure that you get the maximum amount of cash out of the deal, and to make sure that it's a deal that fits well for you. A huge part of that value is added at the term sheet stage, because that, as Mary says, is where we're setting out the structure. You know, there's all sorts of structures that, you know, sound logical on paper and look like a good idea. And then the tax advisors come along and say, yeah, but these are super inefficient and you're lumping yourselves with massive amounts of tax. Again, it comes down to preparation. You want that tax advice, at least in outline, at the term sheet stage, so that you can make sure that the deal that is in the term sheet and that you've, you know, costed out, if you like, to figure out what money you're going to get out of it, that ends up being substantially the same deal as you sign. And certainly in the past, we've had situations where clients have signed term sheets, they haven't got tax advice, generally haven't got legal advice, and then it's transpired down the line that the structure that's been proposed has generated huge and unnecessary tax liabilities for them. And of course, when you're trying to change that structure, potentially you move tax liabilities from the sellers to the buyer, and the buyer may not agree to it. So getting that advice early on the term sheet, vital. And yeah, on an M&A transaction, never ever sign it without the advisors looking at it first.
Never.
Perfect. Thank you so much, guys. We've got so many questions, but I'm going to take only 3 final questions. So the first final question is, how do the responsibilities of lawyers and financial advisors overlap in terms of negotiating a transaction?
Crikey, that's a tricky one. I mean, there is an overlap. The theory of it is that the sort of financial advisors are looking at the commercials of the deal and probably also the sort of the tax structuring as well, generally. And then the lawyers are looking at sort of the legal aspects and making sure that, you know, warranties, disclosure, indemnities are all sort of are all right. I do think it's more complicated than that. I think the areas of overlap, I think there's a bunch actually of negotiation done by both parties. It's a good idea, and you know, deals that are managed properly, the lawyers and the financial advisors will agree with each other before negotiation on any points who's going to do it and the position that's going to be put forward. So the theory is that financial advisors and lawyers are speaking constantly, and that's certainly how it should work. There will be some points that perhaps the lawyers will negotiate, some points the financial advisors will negotiate, and as long as there's clarity on that, it doesn't really matter who does it. But I also think there's a sort of second opinion sometimes. So, you know, when the relationship works well, you know, the financial advisors will say, look, this is what we think we should be doing on this particular point. Run it past the lawyers, and the lawyers will say, yeah, but have you thought about this, and vice versa. So there are often times where we as lawyers will think this is a sensible way forward, that this deals with a legal risk, and the financial advisors will say, yeah, but actually it causes a problem here for us in this particular area. So there is an overlap, but the way that it should work and the way that I would sort of tend to look at it is that the lawyers and financial advisors, what they do is complementary. And certainly, you know, there's some fantastic financial advisors out there. If we're going to name check, Grant Thornton up in Manchester, please.
Yeah.
They've got an insanely good team. And when we worked on transactions with them, it's been very much like that. That, you know, there's a sort of feedback between the lawyers and the financial advisors, and that sort of makes sure that the client gets the best possible deal.
Perfect. Thank you so much. Next question is again from anonymous attendee. What sort of percentage would a financial advisor receive on 100 million sale?
I mean, it depends what you negotiate. I mean, in terms of percentages, and it does vary quite dramatically, but in terms of percentages, probably somewhere between about 5 and 10% is probably about where the market sits. You might be able to negotiate caps on that. You might be able to negotiate some form of split, so there might be a sort of time recovery plus a percentage of deal size. I think the crucial thing was there's lots of points, but I think the most important point is to be clear about what that percentage is based on. And as I said earlier, it must be based on the actual sale proceeds that the sellers receive and not the headline value. So in other words, if it's 100 million quid headline deal, 40 million quid up front, 60 million earn out, and the buyers only get 20 million earn out, well, the consideration should be based on 60, not 100. So that's sort of, yeah, broadly the answer on that one.
I think I'd add that as well as also make sure that you read the fine print, because there's going to be some other fees on top of that as well. So like placing fees, administrative fees, that might be on top as well, and it might be subject to time limit or something like that. So it's always worth having a look, because it can catch you out. You know, once you come to sell and you're about to complete and you're all happy, and then you find out you've got to give a certain amount away to an advisor you appointed however many months ago. You know, it's better to be aware of that. So I think that take that into consideration, as well as the commissions as well.
Perfect, thank you. And the final question for today is from Showcat. What are the typical time scales for a sale from start to finish?
How long is a piece of string? Yeah, I mean, to some extent, it's how long is a piece of string. I mean, I think the answer is it sort of depends where you start from. So, you know, you can appoint financial advisors sometimes more than a year before the transaction happens. It depends on market conditions, sector, you know, where you are in terms of business stage. I mean, a deal we did before Christmas, the financial advisors, I think, had worked in it for like 18 months. So that can be a bit of a movable feast. Once you've found your buyer, we all like to think we can get a deal done in 3 months. Sometimes smaller deals, it can be quicker. So, I mean, we've done M&A transactions in 6 weeks before. But for a bigger deal, probably 3 months is about reasonable. But you should be aware that it can slip. I think the deal we were mentioned a moment ago, just before Christmas, that took, was it 4 or 5 months? Mm-hmm. Yeah, 4 or 5 months. A lot of that though was, well, I would sort of loosely say wasted time, because the buyer was faffing. If you think about from the point that it got super busy and we all, you know, really sort of had deal teams focusing most of their time on it, it was probably about 3.5 months. So that's probably sort of what you want to aim at.
Yeah, and there's always going to be stuff that's outside of your control as well. If there's things that arise during due diligence that mean that we're going to have to extend or cause delays. So, you know, things that have to be, loans that have to be paid off. You know, it might be that if you are supposed to be registered, for example, FCA registered, and you're not, the buyer's going to want you to do that before completion, so that they don't take the risk. So that sort of stuff will take time as well, and it might be that it's just out of your control. So, you know, all being well and good, you know, you'll complete on the same day that you say that you're going to complete at the outset, but it generally, you know, be prepared for that to move. as things happen in life, it might be that it moves and things are delayed, but that's just, yeah.
And I guess on that, so when we say you're looking at 3 months for completion, you generally wouldn't give a 3-month exclusivity. So you're probably looking at a shorter exclusivity for probably 6 weeks, with the knowledge that you're probably going to end up extending it, but it would be probably quite short-sighted to give a 3-month exclusivity because it leaves you with a long period of time when you may effectively change your mind.